Hello everyone, myself Diksha Taneja from Faculty of Juridical Sciences, Rama University. So today I'll be dealing with the topic of rule of law under Article 14. What is basically rule of law? This was a concept which was given by A.V. Dicey. Rule of law basically means equality before all. Every person has to be treated equally, no matter what, no matter the race, no matter the discriminations, no matter the caste, no matter the religion. Every person has to be treated equally. This is what rule of law says. So the first slide which here is, that is introduction of rule of law. This concept was developed by A.V. Dicey, which says supremacy of law over arbitrary powers, which clearly means that the law is superior, that the law is above everything, no matter what the position the citizen holds, but at the superiority thing is just law. No person is above the law, be it any position, any caste, any religion, but nobody is going to be above the law. It forms a basic feature of the Indian Constitution. Okay, so Article 14 is enshrined in the basic structure doctrine. Article 14 cannot be taken away by any power of the parliament itself. Article 14 is basically enshrined under the basic structure doctrine, and this concept was given under the Indra Sahani case, Indra Sahani versus Union of India 2000. Also, Article 14 clears one more thing, that he, she also includes transgender. This concept was given into the case of National Legal Service Authority versus Union of India 2014. Now coming on to the Article 14 meaning and scope. So Article 14 students talk about twofold concept. Twofold concept in the sense, Article 14 takes a positive approach also and a negative approach also. Fine. So guarantees equality before law. This is a negative approach, whereas equal protection of laws is a positive concept. How do we get that? Equality before law is a negative concept which clearly says that you cannot do inequality. This, the word not, is a negative approach, that we are forbidding, that we are prohibiting to do any negative thing. Whereas equal protection of laws is a positive concept which says that all the laws have to be made in such a sense, in such a way, that we have to give equal laws to everybody, equal rights to everybody. So this is a positive thing. The first part is saying that we cannot do inequality. The second part is saying that we will make equal laws for everyone. So in one article itself, we talk about twofold dynamics thing. Then it is given to citizens as well as non-citizens. Then it prohibits arbitrary action, ensures fairness, justice and reasonability. Now coming on to the next part. What do you think, that Article 14 is an absolute right or not? No. Article 14 itself is not an absolute right. It has reasonable restrictions. Now where did that come from? F.N. Balsara, State of Bombay versus F.N. Balsara was a case which said about the concept of reasonable restrictions. It says that Article 14 is not an absolute right, it has a reasonable restriction to it, which was given in the case of State of Bombay versus F.N. Balsara. Two reasonable restrictions were given. The first was intelligible differentia and the second was rational nexus. Now, as I told, there are two concepts in it, the twofold dynamic concepts. First was equality before law, then versus equal protection of laws. Equality before law is a negative concept which says that no special privilege will be given to anybody, which I told. This concept was originated from England. It is an English-based concept, and it also says that like has to be treated likely. What does that mean? It means if I am a student, if I am a student, now I'm a class 8 student. My test, my competition will be with my level people. I cannot compete with, for an example, with a PhD student. So like has to be treated likely. This concept was given here. The next is equal protection of laws, which is a positive concept and has been given in the American Constitution. This concept was given under the 14th Amendment of the American Constitution, as it is a positive concept which expects positive action of the state. Equal protection of laws is a positive concept because it clearly states that the state has to make equal laws for everybody, right? Let's talk about some important case laws. Virendra Krishna Mishra versus Union of India 2015, which says right to equality cannot be denied arbitrarily in absence of valid classification. Remember, I told about the reasonable classifications. So this case simply said that arbitrary action cannot be done unless we have a valid classification to it. Coming on to the next case, DS Nakara versus Union of India, which says that this doctrine of classification was involved to sustain a legislation to state in order to help weaker sections of the society, so that equality has to be given to the weaker sections of the society as well. That is why this concept has been launched. Last case, as I told, State of Bombay versus FN Balsara, which I have recently discussed also, which brought two classifications of reasonable restrictions. Now, a very important case in Article 14, which we can never miss, is EP Royappa versus State of Tamil Nadu. This is a very important case which says that Article 14 is antithesis to arbitrariness, which means that state cannot make any action arbitrarily. State has to provide equality to every citizen of its state. So this concept has been brought by E.P. Royappa versus State of Tamil Nadu, which says that arbitrary transfer of public servant has not to be given. And it was held that equality is antithesis to arbitrariness. It also states that Article 14 strikes at arbitrary state actions. Arbitrary actions is like basically if the state is trying to do whatever they wish like, and this has been controlled, this has been forbidden by Article 14, and that establishes natural justice, as well as it has been given that equality and arbitrariness are, both of them are sworn enemies. That means if you are serving equality, you can never have arbitrary actions. Some more cases, if I would like to say, a very important case, Menaka Gandhi versus Union of India, which says that procedure must be fair and reasonable. Principle of natural justice is protected under Article 40. It says the reasonable restrictions we were talking about, intelligible differentia, rational excess, that also has to be fair as well as reasonable, and which will protect the natural justice concept. Whereas State of West Bengal versus Anwar Ali Sankar says that arbitrary classifications invalid. That the classifications that we were talking about should not be arbitrary. The classifications, the reasonable restrictions also should be fair as well as reasonable. Then just an overview that Article 14 has is one of the part of the Golden Triangle also. The Golden Triangle contains three articles, Article 14, 19 and 21, and Article 14 is one of the most important article in it, which talk about rule of law. It is the foundation of Article 14. Also, supremacy of law has been talked in it, because supremacy of law has been talked at just two places, just two places. First is Article 14 and the other we see supremacy of law in the preamble itself. So judiciary plays a very crucial role in its enforcement, and also Article 14 is very important just to prohibit the state from misusing its powers. Thank you so much.